Captain Mansfield.
Just a minute, please.
Okay. It is one.
Curtis Mansfield, remember me? It's been a
Training
while.
Koenig.
Yes, ma'am. You just tell me when you get ready, we're ready to get started.
I'm ready whenever you are.
All right, Ms. Coleman, for the purpose of this meeting is to conduct an appeal of the captain's determination as it pertains to the Col LLC for violation of Section 13I of the State of Tennessee Department of Safety and Homeland Security Tow Service Manual. Per the policy of the same, this hearing will be tape recorded, and the rules of evidence shall not apply to this hearing. I will ask any and all questions and answers will be directed towards me. Examination and the scope of the hearing will pertain only to the suspension and those events leading up to and surrounding the same. At the conclusion of the hearing, I will take the matter under advisement and render a written decision according to departmental policy.
Yes, sir.
Lieutenant Bratton, would you please advise the sequence of events that led to your investigative report in which you determined Koenig LLC was in violation of Section 13I? And would you please read that policy?
Yes, sir. On 7/19/2016, I received an email from Bob Watson stating he was asked to help on a bill by Ingle Martin Insurance Company, and it involved Koenig's LLC and Wade Trucking. This matter involves release of cargo being held by Koenig's. The email had a letter that he had sent to Koenig's and a copy of the bill, which was all forwarded in the same email. On the next day, on 7/20/2016, I received a call from Mr. Watson in reference to Koenig's not releasing cargo. After talking to Mr. Watson and looking over the email from the day before, I called the owner of the trucking company, Wade Nanny, and talked to him about the issue. On the same day, after talking to Mr. Nanny, I called Koenig's and talked to Trina Koenig. She answered the phone, and I advised her that I was calling in reference to the cargo they were holding involving Wade Trucking. Trina Koenig said that they were expecting me to call and that she would have Ronald Koenig call me back. Ronald Koenig called me back about 10 minutes later. I talked with Ronald Koenig about the cargo they were holding. I told him they could not hold cargo. I advised him to release the cargo. I advised him if he didn't release the cargo that he would be removed from the THP Rotation. Koenig refused to release cargo, and I advised him that he be removed from record rotation, which they were not immediately removed. On 7/21, I sent you a letter, a investigative summarization letter on what had taken place in previous couple of days. Later that week on 7/25, 4 days later, I called Mr. Nanny, Wade Nanny, to check on the cargo. Mr. Nanny stated that the cargo still hadn't been released. Same day on 7/25, I called Koenig to ask him to release the cargo. Talked with Trina Koenig again. She answered the phone and said she would have Ronald call me back. Approximately 22 minutes later, Ronald Koenig called me back. I asked him if he was going to release the cargo, and he said when the bill was paid. I advised him that it was a policy violation to hold the cargo, and if he didn't release the cargo, I would have to remove him from our record rotation. I asked Mr. Koenig again if he was going to release the cargo, and he said certainly when the bill was paid. I advised him that he was removed from the record rotation until he complied with policy. This was on the 25th. On 7/26/2016, the next day, I sent a certified letter in reference to their removal. And the policy. The policy that this is referencing is in our THP policy manual for record companies, 13I. Personal property or cargo contained in towed vehicles shall be released to the owner designee upon their request unless the DOSHS member orders otherwise. Personal property is defined as anything not physically attached or mounted to the towed vehicle. Such items may include, but shall not be limited to, clothing articles, tools, CDs, personal items contained in the glove boxes or consoles, etc. The towing company shall not charge for releasing personal property or cargo during normal business hours.
Lieutenant, to your knowledge, did Koenig LLC ever indicate to you they had changed their position on holding the cargo?
No, sir.
How did the cargo come to be released?
It was released after Hardin County General Sessions Court ordered it to be released.
What date was that, Lieutenant?
That was on the 18th day of August, 2016.
Do you have a copy of that order?
Yes, sir, I do.
What does that order say pertaining to the cargo and the judge's opinion?
Pertaining to the cargo, number 4, the court finds that upon request or demand, the cargo should have been released to plaintiff by the defendant from its storage facilities, and the court finds that written demand for release of the cargo was made by letter dated July 19, 2016. Thus, defendant is entitled to a storage fee for 7-day period from July the 12th until July the 19th, 2016, at the rate of $50 per day, being $350.
Ms. Trina, I assume Mr. Ronald's not coming today?
No, sir.
Okay.
I will be the representative.
Okay. Y'all did get a copy of the towing service manual when y'all made application for the highway patrol rotation list, correct?
We printed one out, yes.
Okay. All right. Since your husband, Ronald's not here, I need your help. I can't read this signature.
That would be Ronald Koenig's signature. If you can't read it, it's his.
Okay. This submission states, I further attest I have read, understand, and will comply with all provisions governing the use of towing services as contained in the Tennessee Department of Safety's Towing Service Standards Manual while performing services requested by members of the Tennessee Department of Safety. I do solemnly swear affirm that all statements made in connection with this application are true to the best of my knowledge, and you are affirming that that signature is your husband's
Yes, sir.
signature? Okay. Ms. Trina, you have the floor. This is your opportunity to explain your position.
Yes, sir.
Enter any related documents or evidence that you want me to consider before rendering a decision. And, you have the floor.
Okay, we'll start with the policy. Your policy cannot be contrary to Tennessee law. Let's just start with Title 47, Commercial Instruments and Transactions. I'm going to give you, and I'm going to introduce that into evidence.
Are these my copies?
Yes, sir, that's your
Okay.
copy. That is Exhibit 1, marked with blue highlighter in the left corner. What it contains is Title 47, Commercial Instruments and Transactions, Chapter 9, Secured Transactions, Part 3, Perfection and Priority. Number 3, Priority. So it's 479333, Priority of certain liens arising by operation of law. A possessory lien. In this section, possessory lien means an interest other than a security interest or an agricultural lien. We did, and we contend that we had a large financial investment in the goods for services provided in good faith to the tractor trailer and the freight. Number 1 is which secure payments or performance of obligation for services and material furnished with respect to goods by a person in the ordinary course of the person's business. Possession of the tractor, trailer, and freight ensured that we would receive payment or be compensated by auction of the items. Number 2 is which is created by statute or of law in favor of the person, and number 3 is whose effectiveness depends on the person's possessions of the good. Without the goods, we had nothing. We have no way to get paid. Lieutenant Bratton ensured that we would not get paid by improperly demanding release of the goods we had a lien on and by giving false testimony in court. B would be the priority of the possessory lien. A possessory lien on goods has priority over security interest in the goods unless the lien is created by statute that expressly provides otherwise. Our interest and our lien took priority over all other interests or liens on the tractor, the trailer, and the freight under Tennessee law. Tennessee Highway Patrol policy, cannot contradict Tennessee law. This is why that paragraph does not read what Lieutenant Bratton claims it does. It would be illegal. Just as forcing us to give up our lien was illegal, suspending us without due process was also illegal. I'll keep that one. We'll go to exhibit number 2. This being your copy and entering into evidence number 2, also marked with a blue highlighter in the left-hand corner.
Okay.
It also pertains to, it is Title 47, Commercial Instruments and Transactions, under Chapter 7, Uniform Commercial Code, Documents of Title, and Part 3, Bills of Lading, Special Provision, and being 477308, and it's the enforcement of the carrier's lien. A carrier's lien on goods may be enforced by public or private sale of the good in bulk or in packages at any time or place, or on any terms that is commercially reasonable after notifying all persons known to have claimed an interest in the goods. The notification must include a statement of the amount due, the nature of the proposed sale, and the time and the place of any public sale. The fact that a better price could have been attained by the sale at the different time or in a method different from that selected by the carrier is not in and of itself insufficient to establish that the sale was not made in a commercially reasonable manner. The carrier sells good in a commercially reasonable manner if the carrier sells the good in an unusual manner in any recognized market, sells at the price of the current market at the time of sale, or otherwise sells in conformity with commercially reasonable practices among dealers in the type of goods sold. I can continue to read that, but I'll let you read that.
Okay, I understand.
Let's.
I've got a few days to look over this. So
Yes, sir.
I assure you we'll review every document that you submit.
Number 3, also marked with a blue highlighter in the left-hand corner, is the 2015 Tennessee Code, Title 8, Public Officers and Employees, Chapter 47, Removal of Officers, and 847-101. officer subject to removal. Every person holding an office of trust or profit under and by virtue of any law of this state, either state, county, or municipal, except by such officers as are by the Constitution removable only and exclusively by methods other than those provided in this chapter, who shall knowingly or willingly commit misconduct in office, or who shall knowingly or willingly neglect to perform any duties enjoined by such officer by any of the laws of this state, or who shall in any public place be in a state of intoxication. We can skip that part. And gambling. Or who shall commit any acts constituting a violation of any penal statute involving moral turpitude shall forfeit such office and shall be ousted from such office in the manner herein provided. Now, we will discuss the case laws. It was upheld in the district appeal from the Chancery Court for Shelby County under Trustmark Bank versus Alvis Miller that they do have the right to a possessory lien and that they shall be above any other lien at that point. We do contend that we did have a possessory lien on that cargo, being as how our bill was roughly 70% of that. Now, he's saying that Ingle Martin contacted Bob Watson. Bob Watson is a third-party antagonist who has roughly 400 to 500 lawsuits against tow companies, and his only way to get paid is if he actually lowers somebody's bill. Now, that being said, the only interest he had in this was financial gain. He had no interest. Ingle Martin is not even an insurance company that covered any of this load. The truck and the trailer were covered by Lloyd's of London, and the cargo is covered by Chubb's. So at this point, how was Ingle Martin even involved in any of this? But yet they claimed that they demanded release of the cargo. The only person that demanded release of the cargo, even through the facts and anything else which you've received, was Bob Watson. Mr. Nanny was underinsured. He called me on the 18th and informed me that his insurance company would not be paying the entire bill and that he would be responsible for it. So we contend at this point that all of this came out of the fact that he was going to have to pay any extra for anything. I did not roll that tractor trailer. I did not fall asleep at the wheel. I did not do any of that. We were asked to be in that situation. We were put in that situation, and we have no right to say no when we are summoned by the Highway Patrol. And if we say no, we are subject to suspension. Now, they are also at this point suing me for $63,000 for the loss of their load through Mr. Bratton's testimony in court. I do have a lien on the truck and trailer through the Tennessee. The possessory lien would be for the cargo. The one thing that we have, the hardest thing of working with the Highway Patrol, is to get paid. When you go on a traffic stop, you have certain key factors that tell you to look further. You hit on key words. Somebody says something, they act nervous, they do something that's out of line. That forces you to go a step further. When we received a call from Mr. Nanny, owner of Wade Trucking Incorporated, telling us that he was underinsured and demanding release of the cargo, that instantly tells us, that's our key word, that we will not be receiving payment on the works that we have performed. You're talking a lot of work out. A lot of equipment was on that scene. When that happened, he instantly called Lieutenant Bratton. Lieutenant Bratton claims to have done an investigation. Would an investigation not be both sides at that point? Would it not be, if he heard Mr. Nanny out and he heard Mr. Watson out. Why is it the only phone call we received was release it now or get kicked off? This coming a day after I had spoke with you on July 19th and complained because he had failed to do a job of adding people to my list. I pay employees, I expect them to be able to do their jobs. That's what I'm in business for. He failed to do that. I called you the next day. I'm being threatened that if I do not release a cargo, which I have a possessory lien on by law, that I will be suspended. On the 25th when he called, he not only threatened again, but he followed through. When he followed through, do you need to take that?
Please, just
Okay.
1 second, I'm sorry, Mr. Chairman. My apologies, Ms.
That's
Cole.
okay. Now, when he did suspend us, he did not follow the process. There is a process put in place that constrains, just as it constrains me, it constrains you too. And when I say process, that's short for due process. There are laws and constitutional rights that constrain the government, and there are reasons the manual says shall in many places. When this appeal exhausts itself, we will have a solid count on who is culpable and how many members were aware but disregarded our civil rights and due process to back an incompetent lieutenant. I contend that I am here solely as a formality, and that your decision to stand behind Lieutenant Bratton through his many errors in non-investigation was evidenced by your refusal to return our company to the list upon the receipt of this appeal to the captain's termination, as we requested, stating your position clearly. I will attend such hearings, and we will see this process to the very end. Now, the manual states very clearly this process that has to be used in order to suspend us. Lieutenant Bratton sent me Bratton. I'm not sure how you pronounce it. I think
Bratton.
I pronounced it both ways now.
Bratton is.
I don't mean to do that. Bratton. It also clearly, under your insurance, makes me 100% liable for anything and everything that happens on the scene, after the scene, all of it. It makes me liable, and I assume full liability for all items of value in the towed vehicles. At that point, that becomes, and that is section 9 that starts and it is on page 15. And it starts the insurance and reads fully, each towing company assumes the liability for personal injury or property damages resulting from a towing company's employee's intentional or neglectful act from the time contact is made to any vehicle being towed. Each towing company assumes full liability for all items of value in the towed vehicle. So at which point does it no longer become your responsibility to tell me how to run my business? As such, I am liable for it. Your liability ends as soon as I sign that tow slip. Let me put a scenario out there. And by this policy that you're quoting, this is how this scenario would go.
Okay.
There's a tractor trailer driving down the road with a bulldozer, we'll say, on top of it. He oversteers, he overcorrects, he whatever happens, his bulldozer ends up 300 feet down a ravine. Now his truck and his trailer are absolutely unharmed. They can drive away, they can do whatever they want. But the bulldozer has to be recovered. Now we recover that. Now the only time, energy, or anything we have dealt with is that bulldozer as cargo. Under your policy and what you're claiming, I would have to give them back that bulldozer instantly, even though I would have, again, a possessory lien on it. At no point in time, but you would expect me to tow a perfectly good tractor and trailer and keep it instead as my collateral for payment. But at this point, the way the courts are going, they want me to give that back too. Do we not understand what kind of precedent this may set for all of the towing companies in this state? What you're expecting us to do is clean up, because that's part of our job. That is spelled out in the manual, that we are required to clean that scene also and make it to where it has never happened before. That way when the people on the roads go by. Now when you do that, how many of the towing companies are going to refuse at that point to touch any cargo whatsoever because we cannot get paid for it? The system is set in place to where these truck drivers have many insurance companies covering every aspect of their truck. Sometimes you have three. So one for the truck, one for the trailer, and one for the cargo. Now if I give the cargo back to them instantly, how am I to be paid for that work that has went into the cargo? How am I going to guarantee under my possessory lien that I am entitled to anything? What the insurance companies want you to do is split this bill in every which way and shape to know who exactly is responsible for which aspect of this entire incident. I'm not dealing with an automobile that has one insurance company. I'm now dealing with up to three. And if one denies a claim and the other two come in for the truck and the trailer and only want to pay their portion, now I am guaranteed nothing because I have nothing. I'm not given the rights anymore to my auction that I am afforded by law to recoup the work, the time, the equipment. Nobody in this room right now knows what it takes to run my business. You don't know what it costs for my insurance, which I'm required to hold $1 million worth, which is substantial. What my bills are every month, or what I have to do in order to stay in business. In a rural area like we are, I don't get a lot. And a lot of them are actually unpaid for. Now, Lieutenant Bratton is more than willing to go to bat for a trucking company that is not even in this state without one time questioning anything that may or did happen on that scene. He never once asked us a question. Was there extenuating circumstances? What is going on? Never once. Not even to this day. He went into a court and he testified what my bill should be. Where did he come up with his figures? From the same third-party antagonist whose only job in life is to actually lower towing companies' bills? Did he get them from Mr. Nanny, who was only on the scene for an hour and a half? Where did his figures come from at that point that he testified in a court of law and signed his name to? He completely threw away 4 people's worth of work, my flatbeds that were used.
Ms. Trina,
Yes, sir.
Can I redirect you here?
Sure.
This is all these charges for this cleanup and allowable charges and all that, that's gonna be addressed
In a court of law.
in a court of law and an overcharge complaint.
It is part of the suspension though.
The suspension is tied only to what we interpret as a policy violation. The policy that we have in front of us to read. We don't have the leisure to interpret it as you could put probably a dozen lawyers read the same thing. We have to interpret it the way our attorneys interpret it. And our attorneys interpret it the same way that we're looking at it, so.
Okay, we'll go back to that then.
Okay, thank you.
On your cargo issue and the fact that, how many vehicles are going to be sold today simply on the fact that they have a lot of cargo room? Personal vehicles.
Are you asking me to answer the question?
You can.
No, I'll.
You not, you don't, that's just a rhetorical question, because that's what that paragraph means. Personal cargo, 100%, and anything else would be contrary to law. And your policy cannot be contrary to law. So we'll leave it at that, and any questions, I'll answer it.
I don't have any further questions, Mr. Attorney. I just want to make sure that you've introduced everything that you want to introduce for me to consider at this point. Are these three documents all you want to leave
Yes.
with me, Mr. Attorney? Okay.
We've already put the paragraph into, and I've already stated that I do not believe he conducted an investigation, that he did deprive me of due process. Make sure one more time that I have everything out in front of you.
You take your time.
Beyond saying that if this does happen and this continues, that I can foresee a lot of towing companies leaving a lot of stuff on the sides of the road, because there are hundreds that know about this now. We do own the biggest Facebook group for towers, and they all know the situation going on.
Understood.
And that policy cannot be interpreted to mean what he thinks it means. That is my stance on it, and when it will continue to be my stance.
I understand completely.
And I will say that at this point, I have been suspended for 60 days as of right now. The first 30 without due process. The next 30 you actually gave me a process to do, and we have an additional 14 right now at this point. That doesn't seem reasonable either. I mean, exactly, because we expected payment, why should we be penalized? Because roughly our invoices equal $1,000 a day on average from the Tennessee Highway Patrol. So you have, in essence, by misreading of this paragraph, will have cost our company $74,000. We've fired 2 employees for this so far. The county is not being covered. There is no coverage in our county. Simply to prove a point to me, because we would not give in to his demand. And we will, like I say, follow this to the very end, because I have no doubt what your outcome will be today.
Well, I hope you don't have a preconceived notion, apparently you do, about the outcome of this hearing.
I most likely do, yes.
But, that's your prerogative also.
I do not believe you are impartial when it comes to Lieutenant Bratton. I mean, that's just my opinion on it. And I took that opinion from the evidence that we were not returned to the list.
You're entitled to such.
Yes.
Anything else, Mr. Turner?
Nope, I believe that will be it.
I appreciate your time. Thank you for coming down.